program.
Thanks, Dwana, and thanks everybody for joining. We have got a lot to talk about, so I think probably just best to jump right into this. We are going to try and set aside 10 to 15 minutes at the end for questions. There is a question, or a Q&A function that hopefully you see on the bottom right hand of your screen. And so if you have questions that come up, please just drop them in there, and we will try to address them as best we can. So before we get too far into what is going on currently with respect to environmental justice, I thought, or we thought, it would be useful just to take just a step back and talk about the historical origins of environmental justice, just to provide a framework, I think, for where things are now. There's a technical definition of the concept, and it is what you see there on the screen. That is at least US EPA's most current definition, which I think pretty much tracks what we've seen the definition look like historically. I mean, the basic concept, right, is that really everybody should have the same degree of protection from environmental and health hazards in their communities, right? That's point number one. And then point number two is everybody should have equal access to the decision-making process, especially when it comes to things like siting facilities in a community, right? So that's the definition, but I think the environmental justice as a concept has been discussed for some time, but it certainly was in the public debate for a while. But really, I think the catalyst for this being a national concern or a national point of discussion was this report, Toxic Waste and Race in the United States, which was commissioned in 1987 by the Commission for Racial Justice, which is an offshoot of the United Church of Christ. And what they did, there was at the time, I think there was a perception that things like hazardous waste facilities and uncontrolled toxic waste sites were being cited in communities either of color, or there are people of color or low income, in part because the people in those communities, I think, were perceived to really not have the ability to fight back against the location of those facilities. But that was the perception, and it wasn't really until this report that we started to get good, hard data on what things actually look like. And so the study it is a comprehensive cross-section analysis of hazardous waste landfills, incinerators, and basically other, heavy industry in communities across the United States. And it looked at many demographic patterns and variables. But what the study found was that race really proved to be the most significant among all of the variables tested in association with the location of commercial hazardous waste facilities and also uncontrolled toxic waste dumps. And this was kind of a consistent national pattern across all of the 50 states where this was studied. And in fact, although socioeconomic status didn't play an important role in the disproportionate siting of these facilities, race really proved to be the most significant factor. I mean, and that remained true after the study controlled for things like urbanization and regional differences. So that study, I think, kicked off the national debate or focus on environmental justice. The Executive Order 12898, this was a Clinton administration initiative that basically instructed federal agencies to identify and address disproportionately high or adverse human health or environmental effects of their actions on the minority and low-income populations, and essentially to develop strategies for doing that. And then also on the federal level, as we moved into the Obama era, we also saw environmental justice actions at the federal level. There was a memorandum of understanding essentially reaffirming the Executive Order 12898 during the Obama administration. There was an action agenda similar to what we've seen now with the Biden administration. And then also there were from an enforcement perspective, the concept of supplemental environmental projects, which I mention only primarily as a prelude to what we'll be talking about later in the presentation. So that's just, again, I thought it was helpful just to have the historical backdrop here for this. And then where I think the rubber hit the road, metaphorically speaking, recently was the Flint water crisis, which, I mean, we really brought to bear, I think in a very public way, the very real effects of how siting policies have had real effect. I mean, so in 2007, the CRJ published a 20-year update to the toxic waste and waste study. And so 2007, I mean, I'll read from the study. One of the things that was in the study was lead poisoning continues to be the #1 environmental health threat to children in the United States, especially poor children, children of color, and children living in inner cities. And that, of course, was precisely the issue that we saw in Flint. So I think the one thing to take away is that this is very much real on the ground, even though the definition, I think, of environmental justice can be somewhat abstract. We're talking about very real problems. And that's, again, I think that's really just the point of the historical context that we wanted to bring here as we talked about more recent efforts. And with that, I will turn it over to Bill Ball, who's going to talk more about that.
Yeah, thank you, Nick, and I appreciate everyone being here today. Again, I'm Bill Ball. I'm based in Foley's Washington, D.C. office, and I am in our federal public affairs shop, so we primarily work on consulting and advocacy on behalf of firm clients with Congress and the administration. And I think Nick teed it up well, where the Clinton and Obama administrations really kind of kickstarted this effort to incorporate community impacts, disadvantaged community impacts, and environmental justice into the federal framework. And, you know, fast forward to the last election, then Democrat presidential nominee Biden and his running mate Harris, you know, really baked into the framework of their campaign platform a significant emphasis on environmental justice and what they later dubbed human infrastructure. That's why we saw just days after the inauguration of President Biden, the issuance of Executive Order 14008, which was a sweeping EO on tackling the climate crisis at home and abroad. Within that executive order was the establishment of the Justice 40 initiative. And that initiative really has kind of built the base and the framework for how all federal agencies will act, whether it's through funding, regulatory, or enforcement, to do it under the premise of environmental justice and make sure there's due consideration. The Justice 40 initiative provision of this EO directed the Council of Environmental Quality, or CEQ, and the Office of Management and Budget, or OMB, who are basically the two clearinghouses for any federal action across the federal government, and the National Climate Advisor, Gina McCarthy, to jointly publish recommendations on how federal resources would flow to disadvantaged communities. this provision also set up a process where those bodies would work together to publish what is effectively, as they called it, an environmental justice scorecard, which would be an annual publication that would, for more or less, score and rank federal agencies on their performance on EJ measures and how they're incorporating it into the base functions of their respective agencies. Subsequently, the guidance that was directed under the EO was released, and it was defined to cover federal programs under the Justice 40, and those programs fell within all these following areas. So any federal program that addressed climate change, clean energy and efficiency, clean transit, affordable housing, training and workforce development, remediation of legacy pollution, and clean water and wastewater infrastructure. So within that, a broad swath of federal actions fell within the Justice 40 initiative. The guidance also directed agencies to ensure meaningful engagement and consultation with disadvantaged communities, which are oftentimes now just with environmental justice areas on any of these covered programs. So theoretically, while a lot of the verbiage in the Justice 40 initiative and the guidance was covering kind of federal investment and funding, these consultation provisions really kind of work to bake EJ considerations into most all federal functions. And that could go with permitting, licensing, enforcement, and anything other actions covered under these programs. And as we'll hear today, this is all being done under existing authorities. There have been no real significant authorities authorized by Congress or amendments to agencies' organic acts to give them additional authority to address environmental justice. And so that's, that will come into play a lot as we have these conversations. We can go to slide 5. So we have seen with that some legislative efforts around EJ and addressing disadvantaged community impacts. As we saw, the Congress passed the bipartisan infrastructure bill, which as part of the measures to offset the cost of that bill, Congress reinstated the hazardous substance superfund excise tax on chemical manufacturers and imports. They also invested an additional, I believe, $3.5 billion in Superfund mitigation work. And so we started to see some congressional action to kind of back up what the administration has been pushing in that infrastructure law. While that was going on, and I'm sure as anyone followed it is aware, the administration and Congress is trying to dual track the Build Back Better Act, which was dubbed by the Biden administration as their human infrastructure provisions. That kind of fell to the wayside a bit once the bipartisan bill got signed into law. But over the past month, some of the more influential senators in this process, mainly Senator Manchin, who's a deciding vote right now, given the breakdown of the Senate, has been having conversations with Senate Majority Leader Schumer on trying to reinvigorate this bill and bring it back to the forefront. While there has been no text of what a new bill will look like, and I'm not so sure we'll see that text until likely late July if it comes together, there are a number of provisions within the text that was passed around in various stages that directly have a nexus to either Justice 40 or environmental justice. One of those is a funding mechanism for OMB to implement Justice 40. And previous versions have had upwards of $4 million for implementing this program. And that includes actions to provide assistance to federal agencies in development and implementation of methodologies and measures to benefit disadvantaged communities, and to actually create this public-facing scorecard annual report that would measure performance of different federal agencies and how they're integrating environmental justice and impacts on disadvantaged communities into their federal actions. It also included a little more than $260 million for the EPA to do a lot of climate R&D and social science that's all kind of surrounding impacts on disadvantaged communities and environmental justice. And also created a qualified environmental justice program credit which would be eligible to universities and institutions of higher education to create programs that would really look at addressing improved data on environmental stressors, particularly those that have adverse health or economic impacts to disadvantaged communities. And so these provisions really are working to, A, implement the Justice 40 initiative, but also looking towards finding creative ways to fund and build out the data subset and framework for which the federal agencies can look at and utilize when they're looking at regulatory decisions, permitting decisions, or theoretically potentially enforcement. There have also been a couple of key pieces of legislation introduced that would look to really codify some of these provisions. As I noted, and I think Nick noted as well earlier, a lot of this process of the administration really trying to address environmental justice and impact on disadvantaged communities has been done so through executive orders, through regulatory work, and through existing authorities. So without direct congressional directive to do so. Senator Booker and Congressman Grijalva have introduced legislation S-2630, which would effectively codify in statute most of these EJ programs, whether it be the larger Justice 40 initiative or programs within each specific federal agency. And Senator Tammy Duckworth has also introduced the Environmental Justice for All Act, which is a little different in that it looks at requiring agencies to consider cumulative impacts under Clean Water Act and Clean Air Act of climate and impacts on disadvantaged communities and how to address environmental justice through that. Would codify the Clinton administration environmental justice executive order that Nick had mentioned, and would ensure significant and meaningful input from disadvantaged communities, from tribal communities, and others in NEPA reviews for any action that has a federal nexus. And so, I think looking forward, and we'll address this a bit later, we're almost into July and it's a midterm, so there's not much time left. Neither of these legislative provisions have had a whole lot of congressional action thus far in committees or on the full House or Senate floor. But they are out there, and there's certainly a lot of interest in the administration and some high-level members of Congress in looking to kind of codify some of these provisions in law to give the agencies a little more directive on how they implement Justice 40 or pursue environmental justice across their programs.
Okay, thanks, Bill. So before we get into taking a look at how this is starting to play out in practice, I wanted to spend a few minutes to talk about what the EPA has been doing recently with respect to environmental justice policy. You could see that there's been, looking at dates here, a flurry of activity from the EPA basically in the past year, really primarily on the policy side, and I do want to emphasize that these are memoranda, they're policy memoranda, they're technically non-binding, obviously, but I think they give you a bit of a crystal ball into how EPA is starting to approach environmental justice holistically, and we aren't going to be able to talk about all of these. We just don't have the time. I encourage you at least, if you have the time and inclination, to at least read the memoranda. Most of them are not that long. There are two that I wanted to just briefly touch on because I think they're instructive. The first is at the top, the April 2021, the using all appropriate injunctive relief tools in civil enforcement settlements. So this memo was a bit of a reversal on a prior memo issued in 2018 during the Trump administration that essentially limited the scope of injunctive relief that could be obtained in a civil settlement to basically just compliance with the law, effectively. This memorandum reverses that and says, well, no, actually EPA can use, and in fact encourages, certain compliance tools outside of and or in addition to just simply compliance with the law and injunctive relief. And so that could be things like, for example, there's some examples in the memo, advanced monitoring requirements, so requiring more advanced sampling and analytic techniques that better detect and monitor pollution for purposes of compliance, right? So this might be something like point source emission discharge monitoring, or ambient monitoring, either at the fence line or at a point source, right? Audits and independent third-party verification, effectively a requirement that the company must conduct either a facility-wide or a company-wide third-party audit on a certain specified basis, right, to basically ensure compliance with the ongoing provisions of settlement. Increased transparency of compliance data. So this is really a settlement provision that says you, company, have to put your monitoring data on a public website, and it is there for all of the public to track. And there's a very action-forcing component of that, right, which is that people will be watching to see if you are in compliant with whatever, the limits to the extent there are limits that the settlement imposes. The other two are steps, which we'll talk about, or we have talked about, and we will talk about more. And then there's stipulated remedies is the other thing that this memo mentions, which are basically, and it's a little vague, but things that if ongoing compliance with the settlement order isn't documented, that something else will be triggered, right? Whether it's another penalty or an SEP, a bit of a stick to keep people in compliance. So that's that one. The other one I wanted to mention briefly, just to carry through this concept of strengthened enforcement, is actually the July 2021, which is the environmental justice through cleanup enforcement action. So obviously this gets to ongoing cleanups primarily under CERCLA and RCRA. But what this memo speaks to are steps that the agency can take to expedite cleanups in overburdened communities, right? And so the examples that are given are things like using UAOs, unilateral administrative orders, right, to compel PRPs to perform response actions, or to provide additional resources if negotiations with the agency fails. Reviewing PRP lead sites, which are designated as human exposure not under control, right, meaning that a remedy has not been implemented that affects public safety, to determine if enforcement actions could help speed things along. And then, I thought this was interesting, requiring PRPs to publish and keep current a schedule of compliance obligations that publicly, so that the community can basically track it. And those, again, those are just some specific examples from just a few of these specific plans, and all of this is captured in the action plan and the strategic plan and the legal tools to advance EJ. But you can see where this is going, right? There is a focus, EPA, increased focus on enforcement and enforcement in EJ communities. And we have seen that start to play out already in some of these areas. And so that takes us to part two, which I will turn over to Pete Tomasi.
Well, thank you, Nick. And with that introduction, Nick has laid out how environmental justice concerns have manifested. They're real, kind of the genesis for the focus for EJ, and Bill laid out the policy. And as Bill noted, EPA currently has no new tools. There hasn't been any legislation passed that has created new authority to implement environmental justice. So, but the administration is very committed based on all the memoranda that Nick had identified, they've scoured their existing authority and have sort of tried to implement or have been moving forward with implementing an EJ in practice with respect to review of projects. So I will talk about how EPA is exercising an evaluation related to environmental justice with respect to projects and permits. And then my colleague Dottie Watson will address how they're doing so in the enforcement context. So I think it's, we now have, over the course of the last year and a half of the Biden administration, we have some data points, both from US EPA, and I would also note the state of California, with respect to how the agency is trying to evaluate and basically intermediate in permitting actions and projects where residents allege EJ concerns. So I am located in Region 5. Region 5 historically covers the center of the country, the Great Lakes, where there's a significant concentration of manufacturing, and historically had been a locus of something like half of the enforcement in the country. And Region 5 has been very active. I'll walk through 3 different matters that they've looked at. California, the Attorney General of the state has actually brought 2 different EJ challenges, and I'll discuss those. And then finally, her cases under the Natural Gas Act has a somewhat unique authority for review for pipeline projects. And there are cases coming out of the state of Virginia and the Fourth Circuit, and I'll address those as well. And I guess I would note, if you're sensing a heavy air focus, that these cases all have that theme that right now, I think ultimately because EPA has the tools to assess projected impacts, is driving a focus on air permitting projects in the review of those projects. So the first case I'll talk about is relates to a facility in Chicago, a recycler named General Iron. General Iron historically was located in an area zoned as industrial on the north side of the city. For those of you who know Chicago, it's in the Lincoln Park neighborhood, I believe near the Chicago River. And in 2018, General Iron announced that it would move its operations from that location to another area zoned heavy industrial, which happened to be located on the city's southeast side, near the Calumet River, which is an area that historically is not far from the Pullman neighborhood. It's an area that historically saw significant heavy manufacturing. General Iron applied for and was issued a pre-construction air permit by the city of Chicago, which issues those permits, in 2020, and moved forward with constructing operations at the new location on the southeast side. After spending approximately $80 million on that construction, community opposition based on environmental justice concerns were raised and were elevated to US EPA's administrator. Administrator Reagan personally sent a letter to Chicago Mayor Lori Lightfoot in May of last year, stating that EPA saw significant civil rights concerns and requested that the city pause its review of permits required for the project and offered the assistance of EPA Region 5's technical specialists to help evaluate the health impacts of the project. That kicked off an 8-month health impact assessment, which is a somewhat specialized tool that looks at emissions and evaluates impacts to potentially sensitive receptors in the area. After that HIA was prepared, it determined that there would be an increase in emissions because it's a project receiving an air permit that would increase emissions. It did not project a significant health impacts to residents, but nevertheless, the city of Chicago earlier this year denied the final permit required to allow the facility to operate. In the meantime, the owner of the General Iron has filed a suit against the city of Chicago. It also sought to reopen, and this is a map. This is the south side location, and this is the original location in Lincoln Park. This is a map prepared by EPA. It is sought to, I believe so far unsuccessfully, to reopen the Lincoln Park operation. US EPA, the city, and Illinois EPA have stated that they're continuing to evaluate the cumulative impacts from the project. And this raises some degree a question of how will EJ considerations work in areas with zoning. For example, Chicago with areas that are zoned industrial, which may overlap with EJ communities. A project in Indiana, it's called Maya Energy. It's a proposed municipal waste facility proposed for Gary, Indiana. It was initially obtained a pre-construction permit to process something like 2,400 tons per day of municipal and construction and demolition waste. Construction has not yet commenced. The facility received a construction permit. After 5 years, it should receive an operating permit. During the review of that operating permit, local residents opposed the project, alleging, among other things, cumulative health impacts, given that Gary, like much of southeastern Wisconsin and northern Illinois and northwestern Indiana, it falls within a non-attainment area for ozone. EPA Region 5 specifically provided a list of proposals that it wanted the state to conduct as a part of review of the operating permit. And EPA also noted that it wanted the state of Indiana to assess its obligations under civil rights laws and policies before approving the location. Finally, a third Region 5 location is Ajax Materials, which sought actually what's something called a minor source permit for an asphalt plant. These are, relatively speaking, minor sources. There are 60 other permitted asphalt plants in the state of Michigan. US EPA actually has a general permit to authorize the construction of these projects on federal lands, including tribal lands. However, EPA commented on the permit for the project, basically requested that the state of Michigan voluntarily apply air toxic standards that weren't triggered under its air laws to this, and include lower limits than those required to meet ambient air quality standards or the prevention of significant deterioration program. The upshot is this is sort of a precedent-setting, location-based review related to environmental justice considerations. So transferring from Region 5 to state of California, two transportation-related projects in California have also been the target of significant EJ focus. So the city of Fontana and South Fontana has, because of location and access to interstates, has become the location of a number of large warehouses in approximately the last decade. In 2020, a 205,000 square foot warehouse adjacent to a high school was authorized by the city for construction. The Attorney General of the state of California brought suit challenging the authorization for that project, alleging disparate impacts to an EJ community. That suit has been settled earlier this year, and this is, again, a precedent-setting settlement. It requires all new warehouses in the city to meet the most stringent standards in the state for emissions limitations. It requires traffic patterns to be evaluated and rerouted to minimize impacts to EJ communities. It requires those warehouses to utilize 100% solar power, renewable power, and to use electric vehicles for any new warehouses built there. And the facility in question that was authorized in 2020 has to distribute 1,750 air filters and spend about $200,000 to a community benefit fund for the neighboring high school. A second California case relates to another cargo facility at the San Bernardino International Airport that I believe is associated with Amazon. In 2019, FAA determined that the proposed facility would not result in any significant adverse impacts to air quality and issued as a part of its review and its environmental assessment a finding of no significant impacts, a FONSI. That was challenged by a community group as well as the Attorney General of the state of California, alleging that emissions and greenhouse gas emissions were underestimated from the project and that the assessment of cumulative impacts to the neighborhood was insufficient. This made its way first through a circuit court and then all the way to the Court of Appeals for the Ninth Circuit, which upheld the FAA's original determination and upheld the determination that the FONSI was, that there were in fact no significant impacts from that project. Finally, leaving California, there have been a few challenges in the Fourth Circuit, and I'll, in the interest of time, sort of just touch on these briefly. But pipeline projects, natural gas pipelines periodically require something called a compressor station to essentially keep moving natural gas along. Those stations are relatively minor sources. Under air permitting programs, they're usually issued minor source construction permits, one of which was issued by the state of Virginia for a project that was proposed to approximately a mile away from two EJ communities. It actually in a relatively greenfield location, but it was somewhat adjacent to two EJ communities. The Fourth Circuit, very interestingly, ruled that even though emissions from the project were modeled consistent with EPA's policies and demonstrated compliance with the National Ambient Air Quality Standards, which by law are set at a level by EPA protective of human health with an adequate margin of safety, that was not enough, and that the state had to determine if environmental justice communities were uniquely susceptible to emissions from the project and would be adversely impacted. The court further said that EJ is not a box to be checked and reversed the project and handed it down. That second similar project that was in the works at the time as a result of that Fourth Circuit decision, called a facility called the Lambert Compressor Station, was denied a permit in 2021 by the Virginia Air Pollution Control Board based on essentially the Fourth Circuit's ruling and a determination that the project would not meet the fair treatment requirements for environmental justice under state law. Now, natural gas pipelines and the Natural Gas Act are usually administered by FERC, and that agency is also reevaluating federal approvals for natural gas projects with compressor stations. What does this mean? This is a paradigm shift. US EPA is really focusing on state law due process claims. And while I've given 3 cases involving air quality, air cases usually come down to modeling and quantitative numbers. This introduces an element of uncertainty for siting of these projects and a level of a question of what is qualitatively enough to demonstrate compliance with environmental justice. The settlements proposed by the state of California really are not based on any guidance. And the additional requirements at EPA Region 5 are not directly tied to any federal guidance or regulatory requirements that drive the explicit requirements. It seems to be agencies and states are suggesting you have to go beyond what that means. It's unclear. And the Fourth Circuit has said compliance with standards that EPA says are protective isn't enough. You have to do more. What that more is unclear. It's not necessarily, there seem to be varying levels of scrutiny depending on the type of sources, if it's a fossil fuel project, and whether there's the degree of pre-existing air pollution. My view is that this is a paradigm shift, and this is we'll have in the years ahead potentially will create headwinds for redevelopment of brownfields projects, for infill proposed for cities, and for future development generally in the non-attainment area. That will create headwinds as well for companies that are looking to reshore or construct near existing operations, pharmaceuticals or other manufacturing projects, and to expand energy production. Somewhat counterintuitively, even though EPA usually favors brownfield development, that may be the only safe option going forward. And with that, I'll hand things over to Dottie Watson.
Hello, and good morning or good afternoon, depending on where you're sitting today. I'm Dottie Watson. I'm a partner in our environmental practice group. Based depends on the time of the year, but sometimes in Houston, Texas, sometimes in Orlando, Florida, and glad to be here with you all today. I was asked to speak a bit about environmental justice concerns in the compliance and enforcement arena. And having been in-house myself for a while, I can tell you this is the one where everybody's kind of scratching their heads and saying, how do we get ahead of this when we kind of don't know necessarily what's coming? So let's talk a little bit about what we see on the table. First of all, Nick mentioned previously, kind of went through the long index of various policy documents that the current EPA administration has put out with regards to environmental justice. The U.S. Department of Justice has done the same, not quite as long of a laundry list, but three key documents that were issued in May of this year, or two key documents, and one of the big things, the creation of the Office of Environmental Justice within the DOJ, kind of signifying that they are expecting that agency to, that environmental justice issues will not only be pursued administratively through the EPA, but also through the Department of Justice as well. They issued this interim final rule reinstating use of SEPs. This was seen as it's a key shift back from what was going on under the Trump administration, but kind of similar in line with what Nick was talking about previously in terms of injunctive relief that is allowable to parties. But the interim final rule reinstating use of SEPs gives EPA another tool in its toolbox to require or ask that settling parties implement supplemental environmental projects to provide some sort of environmental or public health benefit to the community that was impacted when there's been enforcement issues. And that's something that's now been accepted by DOJ and reinstated by DOJ. So this is going to be a big tool used in the environmental justice context for some time to come. And it's really there to kind of go beyond mere compliance obligations. And that's really something that Pete was talking about in the citing context as well, that under the current strategy, compliance isn't enough. It needs to be something more than compliance so that there's actually benefit being, or at least reparation, if you want to call it that, being made to impacted communities. And that's what SEPs are being asked to do in this case. Also, in May, the DOJ came out with its own environmental justice enforcement strategy. And I do think it's pretty illustrative of what compliance and enforcement under EJ looks like overall. First of all, it's kind of a clear directive to prioritize cases that reduce public health and environmental harms to overburdened communities. So, it's giving the agencies directive to go ahead and look at where there's disproportionate impacts and make that a basis for prioritizing some enforcement activities over others. DOJ is directing its people to make strategic use of all available legal tools, including SEPs, which we just talked about, but also including Title VI and other civil rights authorities. So the idea here is don't just stop at environmental enforcement. If there's the Title VI claim to be had, that should be addressed as well. Title VI of the Civil Rights Act is what prohibits entities or persons receiving federal funds from discriminating on the basis of race or creed or national origin. So we'll get into that a bit more in a minute. It's directing their people to create meaningful engagement with impacted communities. And this is really a key focus of the administration, is getting that input, hearing what the communities are saying, and in some senses relying on that to direct what kind of enforcement actions are coming. And as Pete was discussing, what kinds of permitting actions can happen as well. And then lastly, transparency on EJ efforts. And this goes back to what Bill was talking about earlier with the scorecard. The goal of the agencies of both EPA and DOJ is to highlight what they are doing in terms of environmental justice efforts, presumably to keep the focus on there, to see where they're getting wins and see where they need to do some more work. So with all that, it's pretty clear that at least through the rest of this administration, this is going to be a driving force into environmental enforcement cases, both in the EPA and DOJ level. I wanted to talk about a few recent environmental justice federal enforcement actions that I think you'll be able to see a few trends out of what's going on. The first one is the Cahokia Heights, Illinois safe drink enforcement action. This was really to look at water pressure and chlorination monitoring in an impacted community, an underserved community that had issues with high bacterial concentrations in the past. And similarly, there was an action in just June of this year, so earlier this month, around Benton Harbor, Michigan. That community, like Flint, was seeing elevated concentrations of lead, and there was action taken by the agency to kind of force more urgent correction than had been going on previously. So both of those are under the Safe Drinking Water Act, and both of those, I think, you can draw a direct line from what was going on in Flint to the kinds of actions taken by the agency to enforce when there are drinking water issues. The next two are Clean Air Act issues. One is the Lime Tree Bay Refinery in St. Croix. The owner at the time was actually directed to shut down operations at the refinery after multiple air emission incidents. And the facility is being required to get a new PSD permit in order to restart. It was really one of the few instances of EPA using this kind of emergency authority in the air context in a number of years. So very kind of noteworthy EJ enforcement action there. And then similarly with new Indy Container Board, this one is interesting because it actually ordered the company to look at HS limits or HS emissions at the fence line as opposed to at the emission source, because of concerns about impacts that were that emissions were actually impacting neighboring properties. So it changed the scope of what emission monitoring looked like for that facility based on this enforcement action. A couple other ones. There's Tektrex in Gadsden, Alabama. This is a RCRA facility where the facility was EPA actually issued an imminent and substantial danger decision to force kind of immediate compliance. Again, not something that happens all the time, but largely it was done because of impacts that were being seen in the neighboring community. And interestingly, one of the primary requirements coming out of it was for Tektrex to provide security, because there was a risk of neighbors kind of entering the property unknown and unannounced and being impacted by contaminants that were known to exist on that property. So real focus on protecting the community and making it a priority that exposure, even semi-voluntary exposure, would be restricted. And then similarly with TAV Holdings in Atlanta, another recycling facility, this was one that had somewhat of a history of issues, but the enforcement action was really initiated at the request of Georgia Senator Warnock, who noted that impacts to the surrounding community. In this case, again, EPA took some pretty extraordinary efforts to remedy the situation and issued an emergency unilateral administrative order to address the issue. So a lot of times you'll see the agency wait and negotiate and try and work out agreed terms to a consent order, but in this case, they actually stepped in unilaterally and required the company to take action and didn't wait to negotiate. So again, unique thing that we're seeing in these cases, tools that are in the toolbox that don't get used very often, but are in this EJ context. And then lastly, I wanted to mention Tizumi Innovations, which I also think is kind of new and novel in the environmental justice context. This was an enforcement action touted by the administration earlier this month, pursuing claims against a company for failure to register antimicrobial wipes, surface wipes that were marketed during the heydays of the pandemic. Still going on, but I think at the beginning or a little earlier, that's certainly more of the Wild West on this context. The EPA actually imposed the largest FIFRA penalty ever in a judicial settlement, $1.5 million for this failure to register the products. And in talking about this, have specifically noted that one of the drivers was the company's focus on marketing the product to low-income consumers. We don't typically think of FIFRA and TSCA, chemical-based things as hot environmental justice topics, because we often think about environmental justice in terms of facility siting and neighboring communities. But this was kind of the first instance of, or at least for me, one of the few times I've seen it where we're talking about a potentially national community based on marketing or distribution efforts. So I've kind of covered some of these as I've been talking, but lessons learned. One, drinking water is still going to be a big driver. That's always going to be a big focus for the agency, and either under the Safe Drinking Water Act or impacts under the Clean Water Act to drinkable aquifers, I think are going to continue to be high on the list of potential topics for enforcement. EPA is increasing the use of its emergency powers. As I mentioned, these 2 Clean Air Act emergency orders were issued in 2021. 6 had been issued in total in the previous 50 years. So there's certainly a sense of urgency when it comes to things that they view as directly impacting EJ communities. As I mentioned, EPA is not only looking at physical communities, but looking at communities as a market or kind of a nationwide presence when you talk about FIFRA and TSCA. And then attention being paid by elected officials. I mean, it's interesting to note that enforcement action was if not triggered, encouraged by a sitting state senator kind of taking up the issue as his own. So expect to see more of that from the people who have EJ items on their horizon. And I'm going to take a minute to give you the CLE code right now. At this time, for those seeking CLE credit today, please record the following 5-digit code on your attorney affirmation found in the resource list. As you recall, you need to access the resource list, download the form, and then complete this information and return it to Dewana after this session is completed. Your CLE code for today is 09FCR. Again, that is 09er Foxtrot Charlie Romeo. Please record this code on your attorney affirmation form. And now I will turn this back over to Pete. Is it you going next? Yes, Pete. Oh, Pete, can you hear us?
Thanks, Dottie. Going around, I will start and then turn to Dottie, Bill, and Nick for sort of final thoughts. What does this mean for in-house counsel? What does this mean for operations? So I have talked about permitting and projects, and you can sort of distill down, think about this. for your projects, think about this in contracts, and I have a thought for, I think Nick maybe talk a little bit about contracting as well. But if you're going to looking at undertaking a significant project, you need to consider, are we in an EJ area? Consider doing an EJ audit. There are steps. You can potentially reach out to community leaders. You can also, and there's a cost involved, even work up a health impact assessment if the project is worth pursuing and there's a potential area that may have EJ concerns. And finally, there's a question of how do you, traditionally we're big fans of brownfield redevelopment, but is this, is your project one that ultimately you may have to look at brownfields versus greenfield redevelopment? Dottie, thoughts on compliance, or sort of wrap up on compliance?
Absolutely. So, and you'll see a lot of similarities, again, between what Pete was just saying and what I'm going to tell you. Kind of when we think about compliance, what I'm talking about in this context is what can you do with your business to not be that company that's getting a compliance action brought against you, and particularly where you have a large portfolio or you don't know where to start. What kinds of things do you need to think about to know where EJ concerns are likely to come up? First, know your neighbors. You can use EJ Screen, which is a tool that's put out by EPA. It's got loads of information about everything from how many Superfund sites are located near particular properties to air contaminants that are present in the area. It's a multitude of other information. But kind of using that tool and knowing how it works can at least give you a sense of whether you're likely to be in an area that EPA is scrutinizing for compliance efforts. And then also community engagement. Frankly, a lot of enforcement actions start with a complaint from a neighbor or from someone else. So knowing your neighbors, knowing if there are issues, being at least responsive, or dealing with the agency when you're having neighbors issues that you can't directly resolve, are all important ways and ways that I've worked with clients to try and minimize enforcement risk down the road. Secondly, evaluate your site's enforcement history. EPA is going to be looking at sites that have multimedia violations. So you've got hazardous waste issues one year, and the next year there's clean water issues. Those are going to be facilities that are likely to be on the radar in these EJ communities, or facilities with history of complaints. Again, so those are likely to make it to the top of the list. If you have a facility that has some history there, now's the time to set up some good relationships with your local authorities to be able to get corrective actions in place before compliance becomes an issue. And that kind of goes into the next one, which is consider taking advantage of EPA's audit policy. If you do have some housekeeping that needs to be done or corrections that need to be made, or at least you suspect that there is, EPA's audit policy is a great tool to be able to go out, do your assessment, provide voluntary notification to the agency, and that gives you some potential freedom from, or at least reductions in exposure for violations that are voluntarily corrected. So that's an option, particularly for any of these facilities that you otherwise noted as high risk for other reasons. Consider supplemental monitoring. Again, what we're seeing are kind of creative approaches to compliance. So, as I mentioned earlier, fence line monitoring was imposed at a facility in one context. I personally have had clients agree to implement non-required monitoring where there were allegations of something moving past the property boundary, but the client was very comfortable that it wasn't a real issue and that they could demonstrate it if they had the data. It's a risk-benefit situation. Sometimes you can establish kind of good data. Sometimes you end up with bad data and you have to find a way to deal with it. But it is something that's an option, especially as we're seeing citizen scientists out there using some of these non-traditional techniques to institute complaints or base complaints on. Know that you have those tools in your toolbox as well. And then Title VI enforcement, as I mentioned, this is really the next horizon in a lot of ways. As I mentioned before, Title VI allows or requires anyone receiving federal funds to prohibits anyone from receiving federal funds from discriminating on basis of race, color, or national origin in any activity. So this is something that EPA can use as a tool to get movement from state agencies, but it can also be used against public entities, private entities, or other individuals who receive federal funding in one way or another. So it's possible to either cut off the flow of dollars or to seek other kinds of injunctive relief based on EJ violations. So it's going to be a new tool to potentially make it, frankly, more painful where there are violations in EJ communities. And I did want to note that it was just yesterday or maybe the day before, an NGO petition actually went to EPA regarding the Texas Air program, largely based on this concept that the Texas Air, alleging that the Texas Air program was disproportionately impacting EJ communities, and therefore EPA needed to step in and address Texas because of their receipt of federal funds. So interesting update, and we'll see where that goes, but we'll see more of this in the future. And I think with that, I can turn it over to Bill for a few last words.
Yeah, no, thank you, everyone. And forgive me, I changed locations. There was some construction going outside my door. So, but nonetheless, I think, a lot of what we've kind of heard and seen today is it's kind of hard to track exactly where the agencies will go or how they're baking this in, because there hasn't been a lot in terms of congressional action or new authorities and guidelines to kind of dictate that process. We highlighted some efforts in Congress earlier that I spoke of. The most likely to get done is the Build Back Better bill or the budget reconciliation process, which is one and the same. We've heard from Democrat leadership that they likely may be putting new text out at the end of July, but due to the budget reconciliation process, there's a timeline on when that can be considered. And that timeline expires on September 30th. And so if there's not a bill passed through both chambers by September 30th, the budget reconciliation process resets, and they'd have to go through a ton of motions and timelines to set up a new reconciliation instruction, and they won't be able to do that by the end of this Congress. So there's really a pretty short window. That being said, if there are, industry developers or projects that are looking for either provisions to be included in that or looking at trying to prevent provisions from being included in that process, they really want to act now and speak with their members of Congress, or, we're doing that on behalf of a number of our clients now in DC that are Foley clients, and trying to ensure that different provisions are in there. And as importantly, some provisions are not, because it's a pretty fast and loose process. And for the most part, unless you're talking to a couple of influential people, you're not going to really have any insight into the text until it's released. And once it's released, it's pretty much locked down. As far as the other proposals, such as the Senator Booker bill, or Senator Duckworth bill, we haven't seen a lot of action on those in Congress. I suspect we likely won't this year. And given the projections that we very well may have a split Congress next year, with the potential of the House being controlled by Republicans and the Senate maintaining Democrat control, it's pretty likely that we won't see meaningful environmental justice legislation go through Congress in the next Congress. And so the window here is pretty small for additional congressional action. So I think people that are interested, could be affected, really want to think about using their influence or weighing in with members of Congress now to ensure that their concerns or their thoughts are heard on these processes, because it's going to go quick.
Well, thank you, Bill. Nick, did you want to say a couple words to wrap up, or do you want me to? I know we have one question that I think we can tackle pretty quickly.
One question. Why don't we spend time doing that, Dottie? running over time as it is.
Okay. I know we're a little bit over, but I think it's a good question and probably something that a few of you have on your minds. And it's for Pete largely, but for new projects, is there a process or mechanism for getting feedback from EPA and or state agencies on their views on EJ issues before investing time and money?
So it varies between EPA and the state. We actually asked this question of US EPA Region 5, and they have an individual actually in the Office of Regional Counsel who is sort of their lead on environmental justice initiatives. His name is Alan Waltz. And he has identified himself to us as, yes, we will have sit downs with, if you have a project, we absolutely would like to sit down, meet with a project developer and discuss these issues before, if you have a project that potentially has EJ implications. Most, now industry traditionally often isn't terribly eager to have that kind of engagement, but given the stakes on the table, especially if it's likely, that's who I would start with. Each region has someone designated to be the point person, and that's the at least current process. Is they have an informal process in place to set up meetings, and they are doing that. At the state level, it does vary state by state. California has its own initiatives and process, so it's kind of ad hoc at the state level. But federally, EPA is pursuing a voluntary process an informal process of at the regional level of holding these meetings.
Well, thanks, Pete. And I think that concludes our presentation for today. We really appreciate you spending time with us and giving us an hour of your day to talk about environmental justice issues. As you have probably been able to tell by now, we've all been spending a good bit of time with this, both just for our own knowledge, but also with clients that have particular issues. To the extent that any of us can help you with any environmental justice issues, or you just have questions that we haven't addressed on the call today, please reach out. We'll be glad to talk and get you whatever information you need. Thank you again.